Good afternoon, everyone, and thank you for joining us today. I would like to welcome you to FortneyScott's COVID-19 weekly briefing. These briefings are held every Monday and cover the latest topics and developments with regard to COVID-19 that impact the workplace. This briefing will be recorded. Everyone who registered today will be registered for all future briefings. These weekly briefings will continue as long as circumstances develop with regard to COVID-19. I want to address some preliminary items before we start today's briefing. Currently, all listeners' phone lines are muted. At any point in time during the presentation, please feel free to submit a question in the GoToWebinar question box. We will try to answer all questions. Today's weekly briefing addresses the legal and practical issues that will arise when employers reopen their businesses. The presenters include David Fortney, Bert Fishman, and Nita Beecher. I will now turn the program over to David Fortney to start our weekly briefing.
Well, thank you very much, and welcome everyone. We have a beautiful day in Washington, D.C., and candidly, although we're still working from our homes, we're all looking forward to the day that we won't be doing these briefings, but for the foreseeable future, we're going to continue them each week. So joining me today is Nita Beecher and Bert Fishman. And just
good morning, good afternoon.
Yeah, good afternoon, and for those in the European sector, good evening. We're glad to have everyone with us. And just a word or two about our firm. As many of you know, FortneyScott, we are a woman-owned law firm. We're based in Washington, D.C., and our practice really focuses on the federal workplace agencies involving both DOL, EEOC, and the NLRB. And we do have obviously very significant experience in counseling both employers and federal contractors on the full range of workplace matters. Just a quick legal notice about our today's information, which is just that, information, not for purposes of providing legal advice. We would encourage all of you to either consult with your in-house legal counsel or to go with experienced counsel. And many of you we work with on these matters, and we're certainly privileged and appreciate that, and we'll continue to do so vigorously. All right, well, let's get right to the agenda. And Nita, I'm going to ask you if you can tee up what we're going to cover today.
Thank you, David. It's my pleasure. First and foremost, we're going to talk a little bit about how the country is clearly reopening, and for all intents and purposes, the ball's been passed to the states and localities. Then we're going to talk about where we stand on the latest government action, just an update from our last couple of weeks. We had some interesting executive orders and so forth. And then what we're really going to talk about congressional action, especially on liability. I think, David, we got an update on that, and as well as some controversy around the Department of Labor from the AFL-CIO. But our most important time today is really going to be trying to answer the questions that all employers have right now around how do you return people to work? And that's really what our big focus is today. And with that, David, I think you're ready to kick us off.
Sure am. And these are the questions that Nita highlighted are ones that we've been wrestling with on behalf of clients, certainly for the last couple of weeks. Well, first of all, the standards that we're working against are changing. Up until the end of last week, there had been federal social distancing guidelines that were in place. Those were allowed to expire on April 30th. So as Nita indicated, what that means is that we have this, we think of it as a patchwork of various stay-at-home orders. I think we've all seen on the news in some states where they have stay-at-home orders, there's growing unhappiness and a growing willingness of governors in some of those states to roll them back. We have also increasing industry orders, and we're going to touch on that a little bit about what's entailed there, but specific orders governing industries, and it's no longer just healthcare, but it's other workplaces. And we continue to have a multi-state regional approach. The New England states really reaching down to Pennsylvania, Delaware, are a good example of that, where they're working together to coordinate on developing PPE and also in thinking about what the standards are like in recognition that there is a lot of interstate movement and efforts. Of course, many people believe that we now are seeing, and this I think is an organizing theme here, that many in the political side are pushing to get the economy opened, and many are worried about the obvious severe economic consequences of remaining locked down. In contrast, the health professionals recognize that absent a vaccine or any cure, that potentially opening the valve too quickly will lead to potential catastrophic results. So how those get worked out and resolved as this patchwork unfolds is really what people are struggling with. Bert, let's go to you and see if you can give us kind of a little more detail on how some of these state orders are working.
Absolutely. You'll see a graphic. You'll see that there's this kind of, this is the dichotomy that David talked about. It's political. It's also spread throughout the country, but there seems to be a common theme, and that is that the people who are supposed to be going back to work would just as soon not. They feel that the stay-at-home orders are effective, and you can see it's one of the rare moments in the last many years where there seems to be a common agreement that the stay-at-home orders have been effective in, to use the doctor's term, flattening the curve. We can see the next slide. You'll see more of the same, as it were, about the restrictions. A lot of people think that opening now is the wrong thing to do. It's too soon. Frankly, fear is the virus. The virus that infects us all, whether we have symptoms or not. Fear is the universal virus, and you can see it in these polls here, where so many people think that going back to work or opening too fast seems to be the overwhelming majority of people in the United States. And you can see this on the next slide, which is a map of who's opening when. If we could flip to the...
Go to the next slide, please. Thank you.
Here you can see this is the patchwork quilt that David talked about just a moment ago. You can see the various regions that are staying at home versus the various regions that are opening in some form. There is a great variety among the states. The ones in gray have had no stay-at-home orders at all. And the difficulty is, without a kind of national scheme, it really is almost any... It's a free-for-all. And within some states, Iowa, which you can see right in the middle, in the Sioux City area, there is a stay-at-home order because of the outbreak in a meatpacking plant just across the border in Sioux Falls, which is one of the great hot spots in the country. So you literally do need a map, a calendar, and stay in touch not only with state but local authorities to see if your region is going to be opened and when it's going to be open and to what degree. Some areas are opening malls but not restaurants. In almost all areas, schools and child care centers are still closed. Perhaps we can move on and we can get to some of the substance.
I'm sorry, wait just a minute.
I was just going to say, on, if you go back to the map just for a second, it's also important to remember that not every state is open. I live in Missouri, and St. Louis City and County are still locked down, and to some extent Kansas City, because we have probably a third of all the total cases in the state are in St. Louis City and County. So it isn't, as Bert just mentioned a minute ago, you have to really look at where you are to determine how you're opening. Okay, I think we're ready for the next slide.
I think the other thing, and we're going to see this, even these states that are open, the green ones, let's pick on Georgia. They were one of the first ones to turn green. There is clear reluctance, consistent with the survey data that Bert walked us through. There's reluctance by members of the general public to step out and return to restaurants. There's reluctance by workers to go back and to be potentially exposed in that environment. So just turning your state green does not necessarily mean that the state is back like it was on March 1.
In fact, I think the big imponderable for everybody is, if you open, will they come? And the they is your workers and your clientele. And that's the one
right.
question that's now before everybody in the country.
Right. Good. All right. Well, let's talk on next slide a little bit on the latest government action. And on this, what we want to do is really try to recap a little bit about what focusing on the last week, principally the federal government. I mean, the states are extremely active, as we all see on the news, but there's been a lot of action also at the federal level. First and foremost, the president has issued under the Defense Production Act, an executive order that effectively requires that the meat and poultry processors will continue operations. And note that they are to do so consistent with the guidance that CDC and OSHA has issued. Interestingly, this is already, and there's been some litigation claims that have spurned already following this. This was issued on the 28th of April. But there's been litigation about what is the impact of this type of executive order on other laws, both federal and in particular state laws. Does the federal government have the right to mandate that people work in an environment where they may become sick? And what is the impact on the other laws? That is being actively sorted through. I think the response you will see from the administration is, look, it was not intended to endanger workers' health and safety. That's why we made reference to the CDC and OSHA guidelines. And if you comply with those, that's what's reasonable to do. But on the other hand, it is essential that we continue to have meat and poultry in order for the country so we don't have a separate issue there. Second item, just in terms of national standards, more broadly, there was, in effect, of course, a social distancing guidance. This initially was put into effect for 2 weeks. Then the president extended it for another 4 weeks at the beginning of April. That was allowed to expire last Thursday, April 30th. But we still have in place the federal guidance for reopening. And recall, we've discussed that in detail in prior sessions about the gateways at each stage and the 3 phases that are envisioned in that. I think it's safe to say that the guidance largely is written by the medical professional and policy folks.
CDC.
It's got very rigorous medical standards, and we are now seeing some of the political reactions by those that are anxious and are impatient with those medical standards. And we do anticipate, we've been told repeatedly, that the reopening guidance, the federal reopening guidance, is scheduled to be further clarified, amended in the next week or so. So I think likely next week we may have more details on how that's working. Let me just turn briefly on the up the street from the White House, because there's also action in the other branch of government. That would be Congress. Of course, there's going to be another round of pandemic funding. To the extent that the first rounds were viewed as bipartisan, and they obviously were ultimately without as much rancor, it appears that this next round is going to have a lot of political disagreement and issues. First and foremost is the question of whether there will be protection for employers on liability as workplaces resume operations. That bill that issue has really kind of ascended to the front now. With Senator McConnell bringing Congress back. And by the way, if you want an example of a workplace and how they return or don't return to work, look at Congress. One house, the Senate, is back at work, social distancing to the extent practicable. The other, the House of Representatives, will not come back. Neither of them seem to be very comfortable using the means that we're using to communicate with you today. They want in-person presence. So it's kind of ironic to me that they have those restrictions. But with respect to this liability question, Senator McConnell has indicated that he does want some sort of safe harbor for businesses. John Cronin from Texas, third ranking in the U.S. Senate, has talked about a kind of a federal safe harbor concept. The evolving thought is that if there's reckless conduct, that employers should not be immunized from liability for reckless conduct. But on the other hand, if people go forward, if in good faith they follow the guidelines, CDC and OSHA guidelines, and take steps, but nonetheless people do become ill in the workplace, the proposal is that employers should not be liable for that. Similar, there's questions about manufacturers of PPE and other folks that are instrumental to resuming operations and whether there should be some form of liability. What the Congress is trying to do is respond to a number of businesses saying, I'm not going to open and face a massive litigation claim and lose my business because of that.
Right.
On the other hand, to be fair, the Democrats, principally unions and others, have said, wait a minute, we need these protections now more than ever. And this certainly is the last point, not the first point at which we should be letting people off the hook, and businesses need to do everything proper and go forward. So a lot of loose ends. There's going to be a lot of discussion on this and the interplay of workers' compensation, state tort laws, other federal laws, and the interplay with new safe harbors, if any, are still to be sorted out. That's what I see as the major issue. And anyone, Bert or Nita, want to interject on that?
Well, I think the real issue is the degree to which the state laws are, and even federal laws, are impacted by the executive order, for example, that you just mentioned, and whether workers' comp, which is a pre-existing state-funded system, employer-funded system, why isn't that still the exclusive remedy for a workplace incident or injury? And the issue, I guess, is going to be people claiming that by not following the guidances, which are still guidances, that you are somehow negligent and can sue outside the realm of workers' comp. And all of those issues still have to be worked out.
There are already thousands of lawsuits that have been filed, David, around, over and above just liability. You've got timekeeping issues, both federal and state. You have WARN letters that weren't sent out. That's already started. Leave questions. And then I think the major one is going to be, to what extent are employers going to be liable for not keeping employees safe and for negligence or gross negligence?
Well, let's look at see what's going on at the federal agencies. Bert, if you could address that.
Be glad to. We'll be talking a lot in the ensuing part of this about OSHA, so let me just briefly point to the most recent work that OSHA and the CDC have done. They have issued a joint guidance, and we've put it in italics because it is simply a guidance for the meat and poultry industries. In the past, when OSHA has confronted a health and safety issue, they usually issue mandates. They usually issue rules. And if you'll go to the bottom bullet, that's the issue that the AFL and the Secretary of Labor have been disputing about. The AFL complaining that that OSHA and the DOL has shirked its responsibility and made the guidances kind of voluntary rather than imposing standards. And that was a rather heated debate. The letter from the union was very strong, and the Secretary Scalia's response was equally strong. So this is an issue that we'll hear more of, I am sure. Interestingly enough, Wage and Hour, also part of the DOL, was asked to intervene on the use of emergency paid sick leave, and they made it clear that they were going to be very protective of workers' rights. It's an interesting, Philip, just to add that the worker's certification that he qualified for emergency paid sick leave was his report of a phone call from his doctor in Mexico City. Normally, the DOL wouldn't accept such a flimsy evidence. They took it. They said, look, the whole point of this act is to make sure that people who are ill are getting some relief.
Right.
So the Wage and Hour has kind of indicated that they will be broadly protective in this context at least, but the other agencies are struggling with the notion of giving some guideposts for conduct without making them imperative. And that's part of the continuing conflict.
Right. And that struggle between regulations, which is what Wage and Hour is enforcing under extended family and paid sick leave, versus the guidance, which is what we're relying on CDC and OSHA to keep the workplaces safe. So, Nita, what do we do with guidance?
Well, I thought the next slide was very appropriate. If we can move to the next slide, and I don't know if you can hear it, probably not. But for those who've seen the Pirates of the Caribbean, there's a great line in which Captain Barbossa tells Keira Knightley that the pirate code, is more like what you call guidelines. rather than actual rules. And to a large extent, that is what we're dealing with right now. And what does that mean for employers, David? Shall we turn to what a real employer and what he might have to deal with?
Sure. And so at this point, I think that everyone, whether you're in, going back to that map we talked about, one of those states that's green, blue, in between, I mean, ultimately, we're all going to turn green, meaning, be cleared to go back in some fashion. We may turn green
at some point.
We're going to turn green on the map. And how we deal with that. And so we have been dealing with a lot of clients as they are struggling with, what do we do as we're starting to stand up operations. This is no longer, kind of a side conversation. This is the conversation that teams are going forward with. So we've come up with a little fact pattern, and we're going to use this to tease out some of these legal issues for us. In a nutshell, our hypothetical company, Widgets Are Us, it's a manufacturer. It has fewer than 500 employees, so you can think about that the paid leave, new paid leave, family and sick leave covers it. And the Widgets company has a plant in Iowa, and it has headquarters located in New York State. Now, the plant in Iowa, recall that's one of those green states, if you will. New York State is one of the blue states, going back to that map we talked about. And so New York's still subject to home, and Iowa has been cleared, at least at the state level. Now, at this point, so this is a conversation that occurred this weekend, and you're part of the HR or legal team dealing with this. All the workers at the plant up in Iowa were laid off except for the management team. Now, at the 30 folks over in the headquarters over in New York State, some were working remotely, which is terrific, including various executives. Some are on the extended family leave, the paid leave that we've just talked about, and others, in fact, have been laid off due to the business variation. What the CEO said was, gosh, I need to reopen. I want to reopen everything. I want to reopen the line, the manufacturing in Iowa. I want to get headquarters back up, and I want to get moving immediately. So that's your Saturday morning call this past Saturday. And as you're going through that, you start having a number of issues that you, along with other members of the team, are starting to work through. So what we want to do is, off that fact pattern, drill through some of these issues with you and spend our time doing that. We'll pick up questions that you have in the question box in real time as we go along. But let's start with the first real question right out of the box. Obviously, the level of cleaning, I think, is well understood, and that's detailed in the CDC guideline. But as we talk about, the real question is, okay, what do I have to do besides cleaning? What are the first things that sort of come to mind? So, Bert, do you want to start with that, please?
Yeah, I'd be happy to. For those of you who have been listening to us, you might recall in our very first briefing, we said, think of this as a multidisciplinary team effort because you have to think both broadly and minutely. So the first thing you have to do really is think about the return to work process. Think about what you need to do in all aspects, and it runs through your entire company. It's not simply a matter of bringing back workers. It's thinking about what you have to do to bring workers back in, to keep them productive, to keep them safe. You have to follow the OSHA and CDC guidances, which I think are very useful, and you'll be able to see the sites there. The other interesting thing to recall is that although the federal guidelines for opening may or may not still be in play, they do give you significant help. Not many, in fact, none of the states that have reopened, including Iowa, have met the gating criteria that the president issued way back when, just at the beginning of April. But those are significantly important in helping you understand how to bring your workers back and keep them safe. The last is maybe the most important for the success of your business, and that is to implement a communication strategy with everybody. Your key stakeholders, your workers, obviously, your customers, suppliers, communities. You want to tell everyone involved what you are doing to keep them safe as an employee, as a customer, as a supplier, as an occasional entrant. But the main thought that you should take from this slide is the breadth of your thinking. think about the entire workflow. Those of you who were present when the ADA was passed, you might recall how you had to rethink every job description and how surprised you were to learn how physical a desk job was and how mental a manufacturing job was. Well, go through the same process with your work process and think about how you work, when you work, what you need first, what you need second, what you need third for staging it. It's a very, very significant process, and we'll be glad to help with you if we can. But why don't we move on to the next slide?
Your thoughts on that?
Yeah, I have one thought. One thing before we go to the next slide, which we will in just a minute, although let me just talk about it on this slide, to be honest. One of the things we've seen is that employers are using the stages that are set out in the Reopening America guidelines that the president issued in April. And I think that's been very useful because they can use that as a staging process to some extent to decide who's going to come back and when and where, and also the level of the cleaning that they need to continually do and the level of communication. And I think that that's really important to keep in mind as you look at that. How are you going to organize what the work is and how people are going to come back? Now, one of the things I'm not sure everybody's really thought about, and Bert and David and I have talked about it extensively, is work is not going to be the same. You're going to realize now that your CEO says, I don't need all these people. And even if I do need them, I don't need them now. So how am I going to decide? I really would like to not bring back people that are on the vulnerable list, over 65, with disabilities, pre-existing conditions. So HR and legal, tell me who those people are. You know who they are. Tell me. I want to make them not come back. Well, that is the wrong answer. Well, first of all, we've all been in those situations. I hate to say it, but we have occasionally with clients. And the answer is the EEOC has made it very clear that you cannot decide who's coming back based on age, race, or any disability or any of those protected categories. Those clearly will be violations. Instead, what has been done by companies over the years, and you, CEO, have done this many times as you had to lay people off, is what work are you going to be doing? What skills do you need and when do you need them? And use that criteria to decide who comes back. And then you can show that if you get sued, that this was how we made the decisions as who was going to stay and who was going to go, and they were objective, non-discriminatory reasons that you can defend. Having been involved in lawsuits where we were successful and unsuccessful, successful is much more fun, trust me when I say that. You also can explain it, and honestly, in the long term, that's who you want to bring back, are the people who can do the job you need them to do down the road. EEOC has made it very clear, and it's not just federal law. You also have state laws to worry about. And places like New Jersey have at least 25 or 30 different categories that you can't cover. Now, we can talk in a little bit as well. So what are you going to do about those people who might have either themselves or individuals in their household who are covered by the vulnerable categories? So let's talk about who those people might be, which is on the next slide. And Bert, the other thing I wanted to mention before we move on at some point, what about those employers who are eligible for the PPP program and have to keep a certain number of employees? So hold that thought for a second. Yeah. Go ahead, Bert. Go ahead and answer that question.
Well, I was just going to say that if you are, since this is an employer with under 500 employees, he's eligible for the PPE program if he was able to get a loan. In order to qualify for forgiveness, you have to keep approximately 75% of your pre-virus workforce on the payroll and 75% of your total compensation only for people up to $100,000, and you have to be able to document. So there is a rationale in who you pick and how quickly you get them back. It must be by June 30th. So that's another factor if you're in the PPP program that influences how you would respond to all of these.
Anything else, David, before I move on to?
No, I mean, the PPP, I think, runs 8 weeks, 56 days after you get your loan loaded, so there's a detail there. But I think, I mean, one of the touch points continues to be, I'm going back to what the federal legislation that's being talked about, what all of this, everything's always sort of swings back into the CDC guidelines and the OSHA guidelines.
Correct.
Even though they are just guidelines, as our pirate noted, they, as a practical matter, I think, are going to be a bit of a safe harbor legally. They may qualify you if there is this legislation. They are going to be the most help in terms of your communication, in terms of defending what you did, how you did it, this type of thing. With the reminder that Nita's giving us, though, in terms of how you deal with, because there are these various vulnerable persons who've been identified principally by CDC, how we deal with that when we're deciding who comes back and who doesn't. Some people want to come back. Some people don't want to come back. But how do we deal with that situation, Nita?
I think
well,
if I could just interject,
I'm sorry, go ahead, Bert.
Just one, a lot has been made in the press and in the legislature about the difference between guidances and regulations. From an employer's point of view, the thing to remember is those are well thought out, and they are good advice. And whether it's a guidance or a regulation is kind of irrelevant to how you absorb that information and put it to use, because it's really the best thing you have.
I think that's fair. So speaking of that, and I know on one of our earlier talks, so we have employees who don't want to come back. So that's going to happen. People are afraid. We know that. And so what should you do as an employer? So the CEO says, well, I want these people to come back. What am I going to do about that? Well, EEOC has they have done an excellent job, provided a lot of great guidance. You should really, first of all, figure out what kind of accommodation are you going to be providing to people who don't want to come back? What's their reason? Are they saying, I have an underlying medical condition? You should try, to the extent you can, to accommodate that. There has been a lot of discussion, and EEOC mentions this. What if you set up a temporary type of situation where we're going to temporarily accommodate you because you're concerned about being in a vulnerable category or having people at home that are in a vulnerable category? We are going to allow you to work from home, or we're going to put you on, you've used up all your unpaid leave, all your paid leave, so we'll put you on an unpaid leave for some period of time. But the idea here is for employers to be as flexible as possible, because eventually many of these workers you may want to come back, and they try to deal with them as best you can. In the end, I mean, as an employer, CEO, if you want the people back and they don't want to come back and there's no real way to accommodate them or allow them to work from home, you can tell them they'll be terminated if they don't return. And one of the concerns that the employer needs to remember is that they're probably not going to get the unemployment if you fire them for not coming to work, which means they'll be out of luck all the way around and no health care. Other thoughts, David?
Well, I mean, whether it's a firing or whether it's a job abandonment because they declined to return when scheduled and there was no basis for it. I think these are issues that as this situation continues and rolls on, and the growing costs of keeping people on payrolls that cannot productively work remotely and keeping them on benefits that can't work remotely, they need income and so forth, how to deal with it. This issue is one that we see expanding more. All right. Well, let's talk
I'd just like to interject one thing. It's also the nature of your business. If you are a customer-based business that needs good publicity and good PR, just think of being News at 11 for firing mothers who have to stay home with children because their EFMLA has run out. There are a lot of factors that are not simply fiscal and have nothing to do with the law that you have to bear in mind.
The stakeholder interests, and that's why we consciously use the word stakeholder, because it impacts workforce morale, impacts your reputation in the community, suppliers, likelihood of being organized by a union. There are a lot of things that come out of this. So if you reach the point where a company cannot support them, for example, airlines, I predict When they run out of all the federal money and requirements late summer,
Right.
they likely are going to be faced with having to make some very tough decisions and be literally unable to carry the roster that they have.
Right.
Unless people magically start showing up. So we can watch that industry as sort of a case study for this. All right. Well, let's talk about another gnarly issue, which is, should I screen workers? Going back, the EEOC has been helpful. It has said, look, we recognize under the pandemic that people have a lot of questions about whether you can screen workers. By that, we mean collecting medical information on them, principally taking their temperature, but potentially asking them a questionnaire about exposures, whether anyone in their home is sick, whether they traveled to any infected areas or traveled outside the home, out violating a lockdown, that type of information. The EEOC has said, look, we think that that's perfectly fine. So that's guidance, back to a point that we're making throughout. It's not necessarily a legal safe harbor, so we don't know for sure whether a private plaintiff could make a claim of that, but the EEOC has at least said that that is permissible. We've discussed before about what you do with the information. You can keep it in their general medical file, not the general personnel file, and that deals with the confidentiality of it. But what medical information are we collecting? And this, again, goes back to one of our key mooring posts, which is the CDC guidelines. And the guidelines have changed a little bit, actually, over as this situation has evolved and unfolded. Now CDC still says that checking temperatures is desirable. There's a little bit of a difference. Different sources have different points about what is a triggering temperature, but I would go with the CDC guidance. There are lots of gnarly questions about should you check it only once? Can the equipment malfunction? You see the little picture of the infrared thermometers that are widely in use. They have various performance problems. They don't work well in cold environments, etc. What we know today, I think, is under the gating criteria that we've talked about. In theory, you are supposed to be doing this type of temperature check as part of the reentry process. 1. 2, CDC recommends that as a best practice. 3, many employers are not doing this today, either because they can't get the equipment, they can't administer the process, the delays are too long. Even those that have developed kind of an infrared, you walk through and it reads your temperature as you walk through, kind of like an airport scanning device. And then what do you do with the temperature? Does the person go home for how long? CDC says up to 72 hours. Some state guidances say different amounts of time, how to deal with this. So this is a situation where I think at best, everyone, the medical professionals agree, it's a temperature indicator is a rather crude test to determine whether someone potentially is COVID positive. There's many reasons why we could have a fever, most of which aren't nearly as serious as COVID. And you can also have COVID and not have a fever. You can be positive and go in. So many companies are looking at this and saying, even though it's in the guidelines, it's so complicated, including, do I have to pay people when they're waiting in line and being screened, either under federal FLSA or state wage and hour law? All those issues need to be sorted out. I will say some clients that have relied on contractors to come in, nurses or other trained medical staff who are going to administer this part of the program. We have, and they will at least have pretty robust records and be able to demonstrate. They're very focused on CDC guidance, good faith compliance. Others have adopted an interim position. I'll ask people to test at home. Whether that's going to be sufficient and hold up, I don't know, but that's an approach. Still, the third bucket of approaches we've seen on this is we're not going to do it. It's too complicated. It's not specific enough. Too hard, and we're just moving forward. We're going to tell people, we're going to encourage people, come to work only if you're healthy. We're going to educate them on what's there, but we're not going to actually deploy this screen every day at the beginning of every shift. So this is one where there's different views, differing views, and this is one where I think we're really challenged by not having sufficient accurate equipment in sufficient supply. Bert?
Well, the other thing I would add is just as a practical matter, you're a widget maker. You have no expertise You have no personnel to carry this out. You have no way of getting the equipment to do it, and then you don't know what to do once you know what you know. So it is a very complicated issue, and one that is challenging many employers to the point that they're simply, as you pointed out, skipping the whole process.
Well, it raises an issue, one, as we move to the next slide. It raises an issue, though, if you don't follow the CDC guidelines, are you going to no longer have a safe harbor? If you don't take temperatures or in some way get certification, just raising the issue. We don't know.
And this is the question that's going to keep coming, we're going to keep coming back to. And I would suggest, I think today, May 4th, and I put a date stamp on it because it may change, I would suggest that you go through, and if you're not going to do it, you have some reasons why. I couldn't get the equipment. I couldn't find the personnel to do it. I couldn't figure out operationally how to do it. I mean, something. I would not just ignore it. I don't think that's a good practice. All right, let's talk about the next situation. We're at Widget, and some of our workers are out of this new Extended Family Medical Leave Act. When are they available to return?
Well, first thing you have to remember the limitations of EFMLA. It did not add any weeks to FMLA, so you still have that 12-week chunk. Some workers may have used some even before the coronavirus started, but you still have that 12-week chunk, and that's all you have. Also remember the conditions for using EFMLA were very narrow. They focused mainly on the availability of child care or the unavailability of child care and or the precise presence of coronavirus in your home. Further, there had to be work to do at your place of business. It couldn't be a place of business that simply closed down like many restaurants, for example, and many retail stores. So remember that the aperture, as it were, for access to EFMLA is quite small. Let us assume we've now run, even in the best of circumstances, probably 7 weeks into EFMLA, and let's presume that there are people who are 10 weeks into their entire FMLA. They have now run through FMLA, and guess what? The schools are still closed. The child care centers are still closed. From all indications, regardless of whether kids are more or less susceptible, those will probably be the last things to open. So what do you do when someone says, I no longer have any EFMLA, but my children are still home, I don't have a school to send them to, I don't have another spouse to take care of them, I am the only one available? That's where you as an employer have to decide the kind of flexibility you can provide, whether it's LWOP, leave without pay, whether it's a leave, whether it's some extended something, whether it's furlough. Remember, on your sequencing of people coming back to work, this is one of the issues you might bear in mind. Who has other obligations that cannot be easily put aside? But every employer must determine whether and under what terms to accommodate these workers. It is like the previous slide. If a worker is available to work, has no FMLA, and is ordered back to work, they are like that person who ran out of unemployment. They're susceptible for termination and discipline. But I caution you again, these are not the kind of workers you want to be reported on the front page of your local newspaper as being tough with. It's a hard decision. Every employer has to make it by themselves.
I think that's exactly right, and I think we lean back on some of the discussion we had around. And I mean, you could even ask employees, you know, as you're saying, I'm not going to be able to bring everyone back. Are there reasons why you might not want to return? Do you have children still? I mean, you can ask some of those questions of employees and offer them, be flexible. Offer them if they can work from home still for a while. Or again, as Bert mentioned, a number of employers will, I think, be willing to provide a leave without pay. If you have no more leave and you are in a situation, that would at least give them the opportunity to continue their health care at a time when many people don't have any other way of getting it. David, anything else?
No, I think those are the key considerations here. Let's deal with another gnarly issue in the next slide, where we
gave you all the gnarly issues, David.
Yeah.
Your favorite word today.
Yeah, where we look at social distancing if it's not possible. And again, to refresh, 6 feet from each other is what we mean by social distancing. It doesn't just mean when we're socializing. It means when people are working. So if they're on a production line, it means that their workstations are 6 feet or more apart. It means that their desks or work, whatever kind of work they're doing, that people are keeping 6 feet apart, physically apart. This is one where really the liability issues are just really popping, because there are a number of situations where it is very hard to re-engineer. It's relatively easy in an office. You can simply move the desks apart, move the workstations apart, occupy, close your conference rooms. It's relatively easy. In a production setting, though, where your equipment and production process is fixed, it's often very hard to simply if people are standing shoulder to shoulder, such as in a meat production facility,
correct,
where the product moves through and people do work on it, but they are standing, trust me, much less than 6 feet. They're almost literally shoulder to shoulder. If you would put them 6 feet apart, literally over half the work would not be done that needs to be done.
I think, David, this was one of the reasons, one of the impetus for the president's order with respect to meat processing plants. It is simply physically impossible.
Right. Combined with OSHA now releasing further guidance for the meatpacking industry specifically to show, and it basically rests to good faith effort. So not everyone on this call is involved in that type of industry, but we all have work settings. So what this means is you need to make a good faith effort to try to meet the social distancing requirement. We've talked before, the lobbies of buildings, the elevators, the inside space,
bathrooms,
manufacturing, bathrooms, all that. If you cannot, then if you follow, and back to my OSHA guidance, there's a hierarchy here. The first one is that you social distance, you put people further away, and or you add barriers. And we've talked in great detail about that. If not, then you do get to the physical protection, the personal protective equipment, the PPE. And this is where the question comes in settings, but certainly in most workplace settings, the question is, does an employer have to provide it? And in non-healthcare, non-situations where you're dealing directly with exposure to persons, and OSHA has listed what those areas are, generally you're not required to provide it, but you need to go through all the physical restructuring. In the event you can't physically restructure, then you are to provide PPE to the extent practicable. Now, let's go back and pick on meatpacking. Again, that is a situation where traditional protective equipment, the mask, as is shown on the slide, isn't such a good solution because there's a lot of fluid, a lot of wetness that occurs during the course of the day. That means that wearing a mask doesn't work very well for that, a typical type of mask. Similarly, if you put a face shield or other thing, it gets obscured so that vision gets blocked. So, this is why OSHA is saying, look, we're trying to do what is possible. As a practical matter, most of you on this call, I think many employers are allowing people, and some states are requiring people to wear face coverings. Keep in mind that it cannot create its own safety hazard if people are around moving equipment and machinery. It has to be appropriate to be worn. There needs to be instructions on how the equipment, personal protective equipment, masks or otherwise, are to be worn, how they're to be maintained, can they be reused, how they're to be sanitized in between usings if they're reused. There's a whole host of questions that you go through on that. And increasingly, some of the states and increasingly some of the localities are stepping into this. A lot of this is driven by the fact you simply can't get enough, particularly masks, among everything. There just aren't enough N95, which actually most mask coverings simply prevent. They are designed to protect everyone around you, principally, not necessarily to protect the wearer, but in case you are positive, to prevent you from transmitting. But if everyone wears that, the theory is that should aid us. But this is an issue where I think increasingly even in the early returns, I think that most people are going to err on the side of not requiring permitting people to wear masks, at least when they're in contact with other people. And then I think it's important that employers on this point need to understand what the rules are going to be. Get a standard answer. Don't have it different one location to the other. Make an informed answer. Adhere to it. Do the communications, the training, the reminders. If you're requiring masks, if you're in a situation where the public is coming in, you have them put on masks, the hand sanitizers, the basic protocols. Increasingly, certainly in my area, when I go to a grocery store, not frequently, but when I go, you see these same protocols being followed. And I think that generally, think about our office settings, that at least initially, when we come back, we probably would want to make sure that all this has been thought through and calibrated to our setting as appropriate.
Yeah, the one thing I add, David, I'm glad you mentioned the training point, because that's, it's one thing to have a communication plan. That's pretty much written. There's another obligation that will help you show that you're making a good faith effort, and that's help your people understand what you expect of them.
Correct.
Help train them in all of these practices that we're not used to, of not touching, of not collaborating, of being, single file to the men's room, not using the break room. It is a process that is so foreign to our normal practice that you really have to develop some form of training for your workers.
Training and best practices, actually, in certain workplaces with appropriate population size, someone who's going to monitor and remind people to make sure. Well, Nita, let's go on. One of the other issues, of course, is harassment.
Surprisingly.
Yeah,
and I think this is unfortunate, but apparently when people talk about the China virus, as opposed to calling COVID-19, which is not the 19th virus, it is the virus discovered in 2019, the EEOC had to come out and say there have been a lot of harassment of people who look Asian and who look Chinese, and so that EEOC is watching it carefully, and they have done a great deal of work on harassment generally, including harassment of individuals based on race. The other thing that I would be concerned as you reopen is to make sure that people understand those obligations, not to harass. If something comes up, you've got to get right in there, and you need to train remind your managers of what their obligations are. And it's not just going to be individuals who appear Chinese. I think people who have had COVID may come back into the workplace and be treated differently by coworkers who are, again, afraid, and that might be necessitate some not just harassment training, but perhaps civility training, of which EEOC has tremendous resources available on their website.
I also wanted to point out that on this harassment training reminder, those of you that have operations in California, which has an affirmative training obligation under state law, and some other states do too, those obligations remain. So even though you have your virtual workplace, that does not mean that training is on holiday. So those of you that are under those requirements, state law, since there's no mandatory federal requirement, but you don't want to forget that and allow that to get lost while people are on work from home situations.
Right. Connecticut and New York are also in that situation as well.
Correct.
And so David, you need to stay on top. Don't forget the state laws. And speaking of that, David, let's touch briefly on the worker warn, what we call WARN, which is the next slide, the Worker Adjustment and Retraining Notification. So we talked about layoffs. Many people were laid off very quickly. As we know, 30 million people were laid off over about a 3 or 4 week period, probably more than that. And to a large extent, those were probably fall under the WARN exception known as the unforeseen business circumstance. However, as you are bringing people back, if you decide that you don't need everybody and you end up keeping people out for longer than 6 months and you haven't given a WARN notice, there's a lot of questions about whether or not you're going to have liability. And in fact, there are cases already being filed by employees and their employer did not give them a notice. And I don't know if a lot of companies are going bankrupt. So if you are going to lay off employees, or if you realize that a temporary layoff is going to last longer than 6 months and you have more than 100 employees, you need to provide a notice to those employees now, as soon as possible.
Right.
Because your obligation is to give a notice as soon as practical. David?
Right. This goes on the checklist because when the initial layoff occurred, when the virus first and the stay-at-home orders were issued, you have a pretty good argument, I think, that that was an unforeseen business circumstance. However, as part of our rolling back out, we know that resurgence is a real possibility. I mean, the medical professionals have warned us. In fact, they're wringing their hands over this, so we're going to have resurgence. So our point here is that particularly is you have future force reductions if you're faced with that for any number of reasons related to COVID. You need to warn. You may have overlooked it the first time, and maybe you'll get away with that. I doubt that you will the second time.
Right. So, yes, and those of you with contracts and contract workers, even those of us who struggled with high school French, force majeure is now part of our vocabulary. And that's really what the unforeseen business circumstance is, but it doesn't last.
Right.
David, we have one more slide and about
Let's go to
enough
one more.
time for you, David, you and Bert to talk about it.
Okay.
Sure. So let's get to that. And then we want to talk a little bit about if workers refuse to go to work. And I don't know if people saw, but Friday was May Day, Workers' Day in most countries. Not necessarily a harbinger of spring, but celebration of workers' rights in many countries. And it was used by many in the U.S. increasingly to highlight the fact that they're being forced, they believe, to work in unsafe working environments. So let's just take a moment. What's the legal foundation? Can employees refuse to work? So when Widget is saying to the manufacturing people, let's come back to the workplace, and in our example, workers are concerned, and they're saying, no, we won't go back in. Well, the law does give the workers certain rights, and we want to just make sure that, because normally we don't have to worry about these. Number one, if there is a good faith belief of imminent danger, the Occupational Safety and Health Act does recognize that a worker has a right to refuse a work assignment. And
I would
that
say
is
that
something
I would say that the meat packing plants are probably
I was thinking that.
Exhibit A.
Well, we will see whether there is an imminent danger or not, and whether it's reasonable. Because these are the way these things get sorted out. When the company says, look, people in your community may have contracted this, people in the community work here, we've cleaned this plant up, down, and sideways, we've done everything that OSHA required and then some, and you say, no, I'm still scared to work there, that may not be reasonable. So those are the issues that get sorted out under the OSHA Act, under that provision, but they will apply to any workplace. Second, in addition to the individual's right, there is a right under the National Labor Relations Act, whether you have a union or not, for non-union employers too, workers have the right to act in concert for terms and conditions of employment. So if they were standing around, a little example there on the photo on the slide, saying that we're scared, work conditions unfair, we're not being treated well, that arguably could constitute protected activity, and which means that you could not take adverse action against those workers for having engaged in that. Obviously, with social media, the ability to engage in concerted activity and to push this message out is much greater. This goes back to a point that Bert introduced us to, that reiterates here, communication strategy. Got to have a communication strategy. That's the best way to approach it. And discipline, Bert, what do you do with that here?
Oh, golly. Discipline, you're kind of back to where we were with the EFMLA, depending on the nature of your business. In fact, it may not even matter in the nature of business. Think of the trouble that Amazon and Google are facing, the largest companies in the country and the world. If you are an employer who takes direct action against objecting workers who are legitimately complaining about their fears and their health and safety, think about how that looks in your community. Think about, if you're more than a community employer, think about how that looks on the nightly news, where most of us have seen it. It is one of the factors that your communications strategy thinkers should be bearing in mind before they take any action against employees. There are a variety of ways of addressing these issues, and you should think of all of them before you move to discipline.
Thanks, Bert. Well, we have run our time once again. We want to thank you, everyone, for joining us again today. An awful lot of material. Nita and Bert, thank you both very much.
Thank you.
And we look forward to seeing everyone next week. Adriana?
We would like to thank you for joining us today. As a reminder, you may view the previous weekly briefings on our website at www.FortneyScott.com. Please join our next weekly briefing on Monday, May 11th. Be on the lookout for additional updates, which will be sent via email. All registrants from today have been registered for the future weekly briefings. If you have any questions that you would like to have addressed during the next weekly briefing, please submit via email to info@FortneyScott.com. Thank you, and we hope to see you next week.